Welcome to Section 7. In this section, we will be discussing first aid record keeping in the workplace. In terms of Section 24, subsection 1, of the OHS Act, any employer must report incidents resulting in death or serious injury to an inspector within the prescribed period. Regulation 8, subsection 1, of the General Administrative Regulations, states that an employer must, within 7 days after an incident, referred to in Section 24, subsection 1A of the Act, give notice thereof, to the Provincial Director in the form of WCL1 or WCL2 forms. Reports on the actions taken should be clear and promote effective further treatment by emergency support and trained professionals. The first aider should ensure that he or she writes down every detail in the report so that the emergency support and trained professionals can act quickly with the information the first aider provided them. Who will get a copy of the report? The first aider will provide the paramedic with a copy of the report. The paramedic is a medical professional of the emergency medical services who primarily provides pre-hospital advanced medical and trauma care. What do I have to report? The following that must all have occurred as a result of a work-related activity. An injury or illness that prevents a person from doing their normal job for more than 3 days. A major injury or condition. A fatality. An injury to a member of the public that results in them being taken from the scene of the accident directly to hospital for treatment. An injury resulting in a person becoming unconscious or requiring resuscitation. An injury resulting in a person to remain in hospital for more than 24 hours. What from here on? Give the medical nurse a copy, or if you do not have a nurse, give this then to the Human Resource Department. They will act on behalf of the employer and ask the injured person, if available, to complete a WCL2 form, which are required to be submitted to the Compensation for Occupational Injuries and Diseases Act. Recording of incidents. Regulation 9, subsection 1, of the General Administrative Regulations, states that an employer must do the following. Keep a record, in the form of Annexer 1 for a period of at least 3 years. Allow access to the record, for inspection by an inspector, of all incidents reportable in terms of Section 24 of the Act, and also of any other incident, which resulted in the person concerned, having had to receive medical treatment, other than first aid. Investigate incidents, or cause them to be investigated, by a person appointed by him or her, by a health and safety representative, or a member of a health and safety committee, within 7 days from the date of the incident, and finalized as soon as is reasonably practicable, or within the contracted period, in the case of contracted workers. Cause the findings of the investigation to be entered in Annexer 1 immediately after completion of such investigation. Cause every record to be examined by the Health and Safety Committee for that workplace or section of the workplace at its next meeting, and shall ensure that necessary actions, as may be reasonably practicable, are implemented and followed up to prevent the recurrence of such incident. Company policy will accommodate the implementation of legal requisites regarding reporting and recording of incidents in the workplace. In addition to this, management may deem it necessary to implement additional procedures for the company's purposes. Information available in incident reports may assist management with the following. Formulate future policy to incorporate and implement agreed upon proposals to improve the management of safety, health and environmental protection matters. Identify trends developing, for example, recurrence of incidents in a working section. Motivate proposals made to management by presenting facts. Assist researchers by granting them access to information from incident reports. Communicate effectively with elected safety representatives, safety committees, and union representatives. Documentation. It is required by law that all emergency situations must be reported and documented as follows. Once the emergency is over, complete the accident report form and injury on duty form with your head of department, or personnel manager, or safety and loss control manager. Provide as much detail as possible, describing details such as name and contact details of patients, how the accident happened, where and what time the accident happened, what the patient was wearing, any torn or soiled clothing, location of injury, for example, the left leg above the knee, witnesses and names, as well as their contact numbers. The following critical documentation is required for record purposes in the event of legal implications and comebacks. Accident report forms and injured on duty form. Both need to be completed in the event of injury, and every detail must be recorded. For example, the guest slipped and fell on the left-hand side, injuring the knee. Inspection certificates of internal and external inspections done on safety and security, health and hygiene compliances. Schedules of first aid representatives training and certification. The general manager is ultimately responsible to ensure that first aiders are fully trained and meet requirements. Every company will have their own first aid policy. This is an example of the contents of such a policy. It is important that every first aider appointed must have access to this policy. Make sure you understand the policy and ask for clarification within the department if you need any assistance.